Thank you. This case management conference is in the matter of case number TCD 001-2023 and is being held by way of video conference before Her Excellency Justice Maha Mheiri. Any orders or directions made during or after the course of this hearing will be issued by the registry on the judge's instructions. The claimant is a litigant in person and is represented by Mr. Luay Mohammed. The defendant is represented by Nurhan Abdulatif Zaabi advocates and legal consultants. Lead counsel is Mr. Antonio um, Var- Varvaro.
Yes,
Thank you.
Barbaro.
Mr. Luay, you want to proceed?
Apologies, Your Excellency. My name's Nathan Landis. I'm a counsel. I'm representing the claimant in this case, not Mr. Mohammed.
Okay. Mr. Nathan, please proceed.
Thank you, Your Honour. Does Your Honour have, sorry, Your Excellency, does Your Excellency have the case management bundle, which I understand has been uploaded now to the court system?
Let me check. Shahla, do we need to accept it for it to show on our system?
From our end, no, there's nothing that can be done. Can you just make sure, Mr. Nathan, that it has been shared with the registry? Because we are unable to see it yet.
Yes, so the documents were emailed to the registry last Friday. I understand that the defendants have some more documents, but those ones were sent through.
There was an email sent from the registry just less than an hour ago asking the parties to file a case bundle on the CMS or the e-registry portal. So has that been done by either party?
The Mr. Mohammed has uploaded, but he's getting a technical error. So it may not be as resolved as the registry believes.
Okay, can you send it to us through email? We'll open it now.
Yes, Your Excellency.
Okay, Mr. Nathan, you can proceed.
Thank you, Your Excellency. You should have in front of you a set of draft orders, the case management information sheet, case memorandum, and the pleadings as they currently stand. I don't propose to take you through all of those documents. The case memorandum is mercifully short. This is a contract claim in relation to a construction project which the parties have had a disagreement about. And in that respect, it's straightforward. And you'll see from the draft case management orders that we seek to program the matter out, which it depends which version you're looking at. There's a progress monitoring date in early January of next year. And it seems the parties disagree about what directions ought to be made, or whether directions ought to be made today about the other pre-trial directions on the defendant's set of draft orders. They seek to have the matter listed for trial on the 9th of March for 4 days. The claimant's position on that is that while we would like to have a trial date fixed, we don't know whether or not it's going to be 4 days. It may be shorter, it may be longer. And in those circumstances, while we're happy to have a trial date fixed, we'd seek some indulgences from the court in terms of duration once we have a better idea of where the evidence sits.
In relation to the days, that's no problem. We can accommodate. And if the case progression meeting that will happen between the parties, it turns out that you need less days, we can accommodate that. But it's better that we lock in a date, because our judges' schedules in relation to pre-planning next year. Now, my only question is, why do the defendants need until March if the case, the progress monitoring date is in January?
That's probably a question for the defendants, Your Excellency.
You are happy to accommodate a date in February?
Yes, yes, we are, Your Excellency.
Okay.
Can I?
Yes, Mr. Antonio.
Yes, thank you. This is Antonio Barbaro for recording purpose on behalf of the defendant. Actually, we believe that there will be some expert reports which will be submitted, we believe, from certainly from our part, and it has been also, we have been also informed that from the other party, they will submit as well an expert report, and maybe we will apply according to the results of these different expert appointed experts. Maybe we'll apply for a court appointed expert. It will take, we believe that it will take a bit of time. Basically, this dispute is a technical dispute where we have to scrutinize, the court is called to scrutinize and finally to determine about some matters which are typically technical. So considering that there will be an involvement of third parties, and namely, as I said, experts, I think that maybe it will take a bit longer time. But of course, as you said, Your Excellency, as you said, we can. The court is, of course, able to accommodate the dates and to change the dates. So at this point, on behalf of the defendant, I declare that for us it's okay, it's fine. The calendar which you believe is the best at this stage. I'd like to I'd like to, sorry, just one moment. Okay. I'd like just to highlight one point.
Yes.
Unfortunately, we can't hide the fact that we noted a lack of cooperation from the claimant side because the claimant's draft was sent us in a very short time before our let me say implementation integration. We sent to the claimant our draft, but we noted that some activities which we included in our draft had been deleted. Namely, let me take the namely, it was deleted the pre-trial review, trial bundles, reading list and trial timetable, skeleton arguments, and finally the prospected date for the trial. Of course, as I said, we couldn't submit our separate case management order draft because a short time was available to do that. We supposed also to apply for asking a postponement of this case management order, but just to avoid to create also problems also for the organization of the court, at the end we decided that I would have showed these points. I would have highlighted these points today orally.
Okay.
This is about the case management order. About the list of issues, I will wait first what my esteemed colleague will say, and I will reply in this regard.
So in relation to the case management draft that was submitted, do you have any notes in relation to this document, or you are fine with the dates?
Are you asking me, Your Excellency?
I'm asking you, yeah, Mr. Antonio, I'm asking you.
No, the dates, according to my information, because we met some problems about the court system and not working court system. But according to the information, and consider that now I am not in Dubai right now. So according to the information which I received from my team, the dates should be the dates for the pre-trial review 20th of January. Trial bundles, 24th February. Reading list and trial timetable, 7th March. Skeleton arguments, 7th March. And prospective date for the trial, 9th of March. This is the information which I got. I don't know if you have a different calendar.
I've seen this document before that you're referring to. But I'm only saying that since the case or the documents are going to be somehow ready in January, we don't have to wait until March for us to have a trial. So I'm asking the parties to send their available dates in February, and we will look our schedules, and then we will list it.
It's okay. It's okay. Your Excellency.
Short order.
It's okay.
Okay.
Sorry,
Mr. Nathan,
you
have
fine for
yeah, for Mr. Antonio, I know it's fine for you. Mr. Nathan, is it fine for you also?
Thank you, Your Honor. Sorry, Your Excellency, I just missed the last bit you said. Mr. Antonio was cutting across you. Did you say it was that towards the end of February that you were looking at potential listing dates?
I am looking for potential listing dates. I'm requesting your availability in February, and then we will list it for 4 days. I don't want to push the trial until March.
Yeah, thank you, Your Excellency. Perhaps we could list it for 5, just in case there's some, just as a contingency.
Okay.
I just
so you will send us your availability?
Yes, Your Excellency, we will.
Okay. Is there any issues left between the parties that needs to be discussed today?
I don't think so, Your Excellency. I think once the trial date is fixed by the court, then we can fill in the pre-trial review, trial bundle, reading list, and skeleton argument dates relatively sensibly.
Okay. Mr. Antonio?
No, for me it's fine. It's okay. Okay, so I agree.
Okay. So there is nothing that needs discussion for today?
Not from our side, Your
sorry,
Excellency.
maybe there is a misunderstanding. There is a misunderstanding about the calendar. There is no objection for what Your Excellency suggested. It's fine.
Oh.
But about the list of issues, there are some things which I'd like to highlight.
Yes, please.
Okay, thank you. In the list, which in the draft, sorry, in the list of issues draft which we sent to the claimant, there were 3 points which we noted have been totally deleted, and in the new list which our team sent today, I am sure that they have been already introduced. So basically, we believe that it's of paramount importance to verify, to check if the extension of time requested by the claimant for the execution of works have been approved or granted by the defendant. This is really of paramount importance. Second point, if the claimant misrepresented or didn't misrepresent its experience in performing such kind of works, and this is the second point, which is as a direct impact on the request of compensation on the claimed amount, on the amount claimed by the claimants. And the third point, we believe that is once again of paramount importance to verify if the claimant was late in execution of the works. This is from our side. From the other side, in the list of the claimants list, there is point number 20, which is where a topic is, in my opinion, should be rephrased, because first of all, is totally misleading and confused. I read textually. What is the correct amount?
What number?
Number 20. Number 20 list. Number 20 claimants list of issues.
Okay.
I read what is the current amounts for the final accounts for the project. Of course, we are not in the right moment, in the right location, because we are in a case management conference just to discuss about some legal matters related to this sentence. But we believe that this sentence should be rephrased in a different way. And exactly, provided that there are neither defects nor unjustified delays in the execution of works, what is a fair amount to be paid as a final account, if any, to the claimant for the execution of the project? So basically, you have to check if the claimant has executed in proper way the works and has executed on time the works which contractually was obliged to do. So
Mr. Antonio, just 1 second. Have you raised these issues with the claimant before?
So
I cannot hear you. Hello?
Can you hear me?
Yes, now I do.
Sorry, Your Excellency, I didn't hear your question.
Okay, my question is, did you raise these concerns with the claimant before?
Of course, because as I said, the sequence of documents is the following. We defendants, submitted the list of issues draft to the claimant. The claimant returned his list and deleted these points, and we, unfortunately, as I said before, because of the court system not working and the time the timeline was very short to reply, we could include once again these points, but I believe, I'm not sure 100% that our team, so the defendant team, has already included these points in the new list of issues which was sent today. In any case, if you allowed us to send a short email, we can do it in a few seconds in relation to these 3 points which we believe should be included in the list of issues.
Okay, can you send it to the court and I will look at it? Can you send it in draft form?
Your Excellency, I just want to I do need to correct my learned friend here. We received an email from the defendant's lawyers saying that they were in agreement with the documents except for the case memorandum. This discussion about the list of issues it takes me by surprise and frankly has not been raised with us at all. So I do object to my learned friend characterising this as being something that's been raised already.
Mr. Antonio?
No, we have not agreed on this point, not at all. Described what has happened, but we have never agreed exactly on the list which the list of issues draft sent by the claimant was for us was fine. Basically, we accepted what they have done. That's not. There is no. We have not changed our mind. We have not changed our mind because it's very. At a glance, it's very clear that these are really important topics to be discussed. And
I would hate for my friend to mislead the court, so I'll ask him to speak to his instructing solicitors and get them to send to him the email that was sent at 3:53 p.m. on the 11th of August.
Mr. Antonio?
I don't know if I am in this email which my colleague mentioned. I don't know if I am in CC because these matters have been managed. Been managed by the Azabi law firm. So 11th of June now, I received a WhatsApp message according to which I should be in CC. Okay, at 3. So now it's quite difficult to find this mail. 11 of August.
Sent at 3:53 p.m. by your instructors, and it says, pursuant to your email below, the documents are received. If they are submitted as they have been sent to you at 3:19 p.m., we are in agreement on the documents except the case memorandum. I don't understand, Your Excellency, where this debate about the list of issues is coming from.
11 of August. Who is the sender? Who is the sender of this mail? Because I receive many mails every day.
It's come from MD at nalzabalilawfirm.com.
Lawfirm.com.
Okay, Mr. Antonio, please check with the law firm, and then if there is anything, you can send us through email. If you did not reach an agreement with the claimant, send us an email, and then I will look at it. I will look into it, and I will send my reply back by email to the parties.
Okay, thank you. Thanks a lot.
Mr. Nathan, you have anything else?
No, thank you, Your Excellency.
Okay, thank you both for your time. Thank you.